Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elevate.net, ELAWVATE.net, or go online to elevate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elevate.net or fill out a case workshop request at elevate.net. And Rahul and I will look forward to chatting with you soon. This episode of the Elevate podcast is brought to you by FileVine. FileVine has a software program called Lead Docket, which is the gold standard for managing your new case intakes and leads, your Glengarry leads, your Glenn Ross leads, and all of your other leads. So check them out at FileVine and manage your leads. We're also brought to you by Steno. Rahul, you guys work with Steno?
Steno is the best in court reporting services, not just in court reporting services, but even some of their technology tools. We're talking about AI a little bit on this podcast, and their transcript genius, where they can summarize and take interrogatories based on deposition transcripts, is so useful. If you haven't tried it, definitely try it.
We're brought to you by Hype Legal. Hype Legal does digital marketing, web development for trial firms. It's owned by our good friends Micah and Tyler. They recently redeveloped our firm's website, so you can check our website out. If you like it, give them a call, and they can help you out too. And finally, we're brought to you by Expert Institute. Rahul, you guys work with them, right?
We both use Expert Institute because you always need to be cutting edge in the experts that we use in our cases. Going to the repeat experts every single time is going to make you a lesser lawyer, and you always want to keep up, and the best way to do that is with Expert Institute.
Welcome to the Elevate podcast. I'm Rahul Ravipudi.
I'm Ben Gideon. So it's been a few weeks, Rahul, since I've seen you. What's new?
There's a lot new. I actually have some sad news. So, we have the Eaton fire over here in the Altadena area, which is about 3 miles from our house. The entire mountainside got destroyed, along with so many families and lives, and the entire ecosystem in the mountains got pushed out. And so I've got 2 dogs. One's about 15 and a half years old, and the other's 4. And last week, one of them just went out, used the bathroom, and 3 coyotes got her. And so then we took her to the ER, emergency surgery, and she just didn't make it. And so it was brutal to the family, in such an abrupt way, saying, this is the first thing that has been a part of my kids' lives their whole life. So it's been crazy. It's been brutal part.
No, sorry,
but
I'm so sorry to hear that. I can relate because our 13-year-old rescue dog died 2 weeks ago. He had to be put down, just age-related issues, but it was pretty hard on the kids. Yeah, my daughter was literally holding him as they performed the injection, and she described feeling his heart stop in her arms. So it's pretty rough.
Oh man.
There's nothing like losing your dog. It's a hard thing to do. On that very uplifting note, I
know we normally start positive. So Josie turned 18.
Josie did turn 18 last week too, and one of our guests, Chuck, is very familiar with Josie, and Josie loves Chuck. She when she first, actually, interestingly, so Chuck and Elizabeth are our guests on the podcast. They're partners from my old firm at Berman and Simmons, and Chuck was there at the kind of the genesis of this whole podcast because he was out at the Tucson American College meeting where we hatched the
Oh,
plan and met
yes,
Rahul. I don't know if you remember meeting Chuck
I
there,
do.
but then there was he was playing ping pong with Josie
Yeah,
over by the
they
pool,
called
and
security.
yeah, this like kind of weird looking old man was there, and my mother, Josie's grandma, was like, "What's going on over there with this weird man playing ping pong with my granddaughter?" So,
Ben had to intervene, or I was going to get handcuffed.
we learned that Chuck's mob name was Chuck Collada, Chucky Collada. So then that's what Josie now refers to him as when we talk about Chuck. How's Chucky Collada doing? So. Yeah,
That
so
sounds like a version of a pina colada. It's
right.
not a dangerous mob name.
I think that might have been the idea of it, but I don't know.
Yeah.
Chuck can elaborate if he
I
wants.
don't think it was complimentary, Rahul.
You don't argue with it when you're assigned it. So yeah, I've been really excited to have Chuck and Elizabeth on the podcast. They've had a string of great verdicts, which I'm sure they'll talk about. I actually first got to know Chuck when he would partner with us on cases at Berman and Simmons. In fact, I think the initial case we did, this was the kind of the urban legend. I wasn't there for the discussions, but I remember hearing that one of our partners and one of my mentors, a lawyer named Julian Sweet, had turned down this case involving a little girl, and they had found Chuck to do the same case, and then he came back and asked Jay, Attorney Sweet, if he would partner with him. And I think Chuck said something like, "I hear you're the best medical malpractice lawyer in the state of Maine." I guess that's kind of like being the tallest man at a midget conference. But given that, I would decide to partner with you. And they did partner on that case and got a great result. And then kind of the rest is history. We partnered on a number of cases, one of which Elizabeth and Chuck and I worked together on. The Kimberly Young case. Chuck and I have worked on many other cases. And I have to say, I've learned a lot from Chuck. He's really a terrific lawyer. I follow many of the things that I've learned in terms of my own practice, the way I work with experts, particularly, and the way I manage staff on cases. So I really feel like Chuck has been a mentor. I've learned a lot. He's a great lawyer. And I would say the same for Elizabeth. We've worked closely on a number of cases. She's a terrific lawyer, and I'm sure the two of them together are an incredibly formidable force, particularly in a courtroom. So with that, guys, can we one thing I don't know a lot about you, Chuck, is you said you were a shepherd and maybe you were a dairy farmer, but I don't know what your actual life story is. We can start with that.
Well, thanks, Ben. I appreciate the kind words. And Rahul, I'll say that many of the things that Ben says are true. Many. Yeah, I grew up in Ohio and went to Ohio State University and ended up at Penn Law School and in Philadelphia, and did not go the same route as you guys. I thought I wanted to do the big firm thing. I guess Ben and you didn't feel that way, but for me, I went to a big law firm in Philadelphia and worked there for several years and hated it, just hated it, and really didn't know what I wanted to do. And so I left and became general counsel for a corporation and didn't like that much better. And it wasn't until I got fired as the general counsel that I finally said, maybe I should do what I want to do. And I was interested in medicine. And so I hung out a shingle and decided I was going to be a medical malpractice lawyer without realizing that having no assets and no experience and no clients, it was probably not a great idea. But when you're stupid enough to do stuff like that, you actually fight through it because you don't know that you can't. And so I actually ended up having some initial success and joined a very successful plaintiffs firm in Philadelphia and worked there for a long, long time until I decided to move to Maine. And, and as Ben said, work with this firm, Berman and Simmons. Unfortunately, right after Ben left, so Ben and I didn't get to work together too much, but we did do one case together. I think at the time had the largest medical malpractice settlement in the state history in that case that he and I did.
And Chuck, just one more thing. I know I've heard in kind of your early days, you developed this expertise in pediatric metabolic disorders. And how did that all come about?
Well, again, like keeping it real on the podcast, working in Philadelphia, some of the lawyers there, Tom Klein, Shane Inspector. And before those guys, they worked for somebody named Jim Beasley. And there were guys like Richard Sprague and Jim Beasley that were working in Philadelphia. And the idea that you were going to get a case, when the competition was those guys, it wasn't going to happen. It would be like if you were a young lawyer in Los Angeles and they were picking between Brian Panish or Rahul Ravipudi and you're not going to get the case. And so you decide, I think, really early on that you have to specialize and develop a niche where you can really be a subject matter expert and have an argument about why somebody should hire you. And so I started to get involved in inborn errors of metabolism and genetic disorders, which was sufficiently complicated that a lot of the lawyers in Philly didn't want to deal with it. And that's how I kind of got involved in that because it was the way to survive, really.
Yeah, we can circle back to that a little bit later. Elizabeth, so you kind of have a different pathway. I know a little bit about it, not the full story, but what I know is you come from a pedigree of fine lawyers. Your dad was a partner at the most prominent and prestigious big firm in Maine, and then went on to become the judge on the First Circuit Federal Court of Appeals. I guess he's personal friends with John Roberts. Your sister's also a lawyer, as I understand it. I remember working on a political campaign, and your mom was our finance director. So you have a very plugged in political and legal family. But tell us more about that and how you ended up, uh, like we discussed, becoming the black sheep plaintiff's lawyer of the white shoe family.
That's right. I always knew I wanted to be a lawyer. I wanted to be in a courtroom trying cases. It's just what I loved and wanted to emulate seeing from a young age my father doing. If you had told me in law school that I was going to be a plaintiff's personal injury lawyer working on contingent fee, I would have laughed at you and said, "You're absolutely crazy." But ultimately, what it came down to when I got out of law school, I wanted to be in the courtroom trying cases. And I knew going a big law route, that wasn't going to be an option. And I had the good fortune to be offered a position with a boutique trial firm in Boston, where I came under the mentorship of just an incredible attorney, Lisa Arrowwood, fellow of the American College. Learned a lot from her, and she really imparted a love of these contingent fee cases representing people who had been injured. And that's how I built my practice over time. And eventually, when I moved back to Maine, where I grew up, that's what I wanted to focus on exclusively. But as you say, yeah, I'm the one contingent fee lawyer in the family. My sister's a lawyer, my husband's a lawyer, my brother-in-law's a lawyer. We're no fun at all at family reunions and cocktail parties. But I'm the only one who's embraced the path of plaintiff's work, and I'm so glad that I did.
Elizabeth, was the practice and trial work all focused on medical malpractice, or did you run the whole gambit?
The whole gambit. In fact, initially I used to do defense work as well, employment defense, as well as just some general civil litigation defense. So I got a really good broad exposure back when I was practicing in Boston. But the cases I loved most were personal injury and medical malpractice. So that's increasingly over time where I focused my attention.
This is it's always so fascinating to me because medical malpractice is not a sought after practice in California. And so, just general question to both of you: what attracts you to medical malpractice cases?
For me, I think it's the power differential. There's so much trust that patients put in their healthcare providers, and there's a lot of responsibility in the care that's delivered. When there are preventable medical errors, I don't think the consequences of those should be borne by the patients. I think that we need to take advantage of the system of insurance that's set up to make sure that those risks, that those lifelong effects are borne by the insurance that these healthcare systems are paying for year after year. So for me, it's a real point of passion. It wasn't very fun to introduce myself to my in-laws when I met them for the first time. They're both practicing doctors, and kind of skirted around what I do for a living and what types of cases I turn on. But yeah, it's really rewarding work to do, and it feels really righteous taking on the cases that we do.
Yeah, Rahul, they have a pretty tough law in California, don't they? Was it MICRA? Is that what it's called?
In Micra, yeah, and fee caps, terrible jury instructions, caps on non-economic damages. I mean, it's prohibitive in pursuing those types of
I
cases.
remember doing a case up in San Francisco, and I was shocked by some of those rules because they none of that is present in Pennsylvania, where I was practicing.
How about the jury instructions? Are the jury instructions manageable on a professional or medical negligence case?
Well, most of the states have pretty standard medical malpractice jury instructions. So, I usually walk in and say, I want the standard instructions, and they're going to give you 72 instructions that are complete BS, and there's no reason why we shouldn't do the standard instructions. And virtually every time the judge just does the standard instructions. So I don't actually think they're that difficult.
One thing I've noticed about you, Chuck, is you really seem to get into the science of the cases and the medicine. You seem to enjoy that and learning about that. Is that, part of it?
Yeah, I mean, it's funny. I listened to Elizabeth, and she got into things for all the right reasons. She wanted to help people, and I like helping people. But I admit that when I started medical malpractice, the reason I did it is because I was really interested in the science. I mean, that I wanted to do something. I felt like I wasn't a good lawyer when I was representing corporations because I wasn't interested in it, and medicine interested me, and so I got into it first because I thought, let's do something that I actually care about. And then later on, when you start representing real people, then you realize, wow, this is a righteous thing to do. These people have really been seriously injured, and I'm really proud to represent them. But in the beginning, it was all about the science for me.
And circling back to that pediatric metabolic type of case, because there may be lawyers out there around the country that have something like that and don't even recognize what it is. Can you just give us a little primer on that?
Yeah, I mean, every kid in America gets a prick on their heel when they're born, and they take a couple of drops of blood and they put it on a piece of filter paper and they send that to a laboratory. Every baby in America, unless the parent opts out of it, which almost none of them do. And they're testing for genetic diseases that are inherited, typically recessively. So if I, have a child with my wife and we each have different mutations that are recessive, the chances of them being the same are very low. But if you do happen to get married to somebody, have a kid with somebody, whatever, and they have the same mutation, there's a 1 in 4 chance that they'll get both bad genes. And then they have a series of dozens of these diseases that can be devastating if they're not treated early. So that's why they screen for them. I started getting involved in it because early on, they were only screening for a few of these diseases, even though tests were available where you could screen for dozens of them. And states were very slow to adopt that. And in fact, the case I had in San Francisco, Rahul, was exactly that. We sued John Muir Medical Center because they failed to offer expanded newborn screening to a kid who was then devastated by not getting that testing. And they were actually they were piloting the testing in the newborn nursery, but they didn't offer it to the kids in the NICU. And I thought that made no sense whatsoever. And we ended up, being very successful in that case. But that's what those cases are about. They're treatable, inherited metabolic diseases that every kid now in America is screened for. Unfortunately, those kids don't get very good medical care a lot of the times, and there's still cases involving them. The way they come up in a lot of medical malpractice cases is, and in the case that we were going to talk about today in Pennsylvania, if a child has a bad outcome and the defense wants to say, yeah, it wasn't because there was intrapartum asphyxia, they actually have an inborn error of metabolism that nobody could know anything about. It's often a defense used by hospitals to defend birth injury cases.
Are there names for some of the more common conditions
Yeah, the
that you
most
see?
common one is called PKU. It stands for phenylketonuria. But there's also they all have tongue twisting names. Nobody I think would ever have heard of them, and some of them are quite bizarre. Actually, one of the most common is called maple syrup urine disease. Believe it or not.
I
Um,
feel like I have
What's
heard of
that?
it.
it's a protein metabolism disorder that causes brain damage if you're not treated, and they call it that because people's urine when they have it, if they're not treated, actually smells like maple syrup. It's sugary.
Yeah.
So they're all very obscure diseases, but collectively, about one in every few thousand kids will have one. And if they're not identified and treated, the outcome can be devastating.
And what is done to treat these conditions?
If you can't metabolize a certain amino acids are the building blocks of protein. If you can't metabolize that amino acid, then they give you less of it. You had special formulas and special diets so that the thing that you can't metabolize is taken out of your diet, and then there isn't a big buildup of it behind the block in the metabolic pathway. So they either give them things that they're missing or they take away things that they can't metabolize.
I seem to recall the first case that I alluded to that you did with our firm way back. That was a little girl, I think, who went to the hospital, and she had a protocol that they were supposed to follow because of an underlying condition, right? And then they ignored that protocol.
Yeah. A lot of these kids have diseases where they become hypoglycemic very quickly. And that was what was true of that little girl. The parents had a protocol, but they hadn't updated it. And so they printed something off the internet and came in and told the doctors, this is what you need to do. And they got laughed at, because they had something they printed off the internet. And they kept begging the people to give her glucose, and they didn't do it. And then she suffered a cardiac arrest. So yeah, that was the first case that I did with my current firm, your old firm, Ben.
Elizabeth, I've noticed you're taking on more sex abuse cases. Is that an area of focus for you?
Yeah, it's always been work that I've done. I don't know that I'm taking on any more than I used to. I just think it's the type of thing that there's been increasing recognition of and publicity over as sort of social norms shift and recognize more and more when survivors reach a point of their lives that they're ready to come forward. So it's a skill set that's very similar to what we do with other types of catastrophic injuries, whether they're physical or emotional. So I see a lot of common threads in the work that I do, whether it's medical malpractice or, trucking crash or sexual abuse.
The sexual abuse cases, what do they arise out of? Is it foster care, school systems, juvenile detention facilities?
Yeah, one of the tough things about these cases is that they arise in every walk of society, but only sort of certain situations are cases where they're recoverable, where they're collectible, because of difficulties of proof, but mostly difficulties of collectability. Sex abuse, of course, isn't something that is typically insured against. And so, trying to find a situation where there was someone, usually other than the actual individual perpetrator, who was in a position to stop the abuse, to protect the child or vulnerable individual, and who failed to do that, whether it was policies and procedures or supervisory negligence. Those are usually the paths that we're able to take to make these cases collectible.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. psrplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. PSRplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at PSRplaybook.com and learn from the best.
So you guys want to talk a little bit about your last trial? I think it was a med mal case in Pennsylvania, and you guys tried it together. And maybe you could tell us a little bit about how you divide up the labor and your overall tactical approach and strategy going in, and then what actually, transpired in the courtroom.
Yeah, this was a real beast of a trial that we knew we were facing, and I was really excited when Chuck got me on board and explained to me this would be a 3-week trial, 20 experts, a dozen witnesses. It was a real sort of a real big case, a trial lawyer's dream to try, and that was very professionally exciting. It involved a little boy who had he'd sustained devastating injuries when he was administered a dosage of morphine and other narcotics at the hospital following a routine surgery. Those drugs put him into respiratory arrest, and he suffered a brain injury from the lack of oxygen when he sort of became unresponsive in the car seat on the ride home. His parents had never been told he'd received anything other than Tylenol. They'd been told that he might be a little sleepy, he might be, needing to rest the rest of the day. So they had no idea that anything was out of the ordinary until they went to try to wake him up, and they couldn't arouse him. So they rushed him back to the emergency room, and that's where they learned what had happened.
It was World War III. The hospital hired the sort of the most experienced, toughest defense lawyer in Philadelphia. And this took place in York County, Pennsylvania. So this is southwest of Harrisburg on the Maryland border. It's a real red county in the middle of, central Pennsylvania, which is a real red section, very Republican. And I think the jurors, are fair there, but it's not like going into Philadelphia or Cook County or something like that. It's a very conservative area. And they decided that they were going to fight everything. They weren't going to concede anything. And it ended up being a 3-week trial. And the complication in the case was this child suffered this sort of devastating injury, but then he went into rehab, and over the next 4 years, his motor skills and abilities actually got a lot better. So he made thankfully, he made a really, we thought he was going to be in a wheelchair. He made a really beautiful recovery from a motor perspective. The complicating thing in the case was that as the trajectory of his recovery in the motor area got better, his social and learning issues got a lot worse. And we really had a hard time understanding that. So by the time the case was coming to trial, if you weren't like a neurologist or something, you would have a hard time seeing that he had any kind of motor issues. But socially and from a learning perspective, he was really struggling. And so much so that people thought that he had autism spectrum disorder. And so the challenge in the case was, how do we connect that to what happened to him as a 4.5-year-old child when he clearly had this respiratory event and suffered a brain injury? And I don't know if Elizabeth wants to talk about it, but this was one of the greatest challenges we'd ever faced in a case, because the case we thought we were trying, which was a child who was in a wheelchair because of a hypoxic injury, became something very, very different, very recently, shortly before trial.
Yeah, just really in the months leading up to trial, the child's parents had taken him to see a new provider to follow up on some longstanding concerns about visual processing. That evaluation, combined with follow up with his ophthalmologist, led to him being diagnosed with cerebral visual impairment, also called cortical visual impairment, or CVI. Um, that was a real watershed moment of the case, because for years of litigation, we had been preparing to try a very different case than the diagnosis that we now had. A diagnosis that answered a lot of the questions we'd had about why this child had particular challenges, why his motor functions had recovered in such a miraculous way while he still lagged behind socially and emotionally. So it was, in some sense, an aha moment. Medically, it explained what was going on, but it meant that in very short order, we had to get amended designations from every one of our experts. We had to change our trial strategy. We had to cull through exhibits and photos and videos and everything that had been sort of selected and produced in anticipation of a trial that would be focused on different issues. We were really left in a situation where we had to put on a case with the preparation that had been done for sort of a very different sort of legal theory and diagnosis that had made sense at the time. but was not what we would have necessarily done in the lead up if we had known where the endpoint would be of the child's diagnosis.
So Ben, the thing that I think is interesting for anybody who does medical malpractice cases, and I truly did not know this. We sent him to a developmental pediatrician because the defense was saying, this kid's made a miraculous recovery. There's nothing really wrong with him. And his school grades were pretty good. We sent him to a developmental pediatrician, and she said his behaviors are consistent with autism. And the parents didn't like that diagnosis, and they took him to Johns Hopkins, and they said, no, his behavior is consistent with autism. And the defense was like, this is great because hypoxic ischemic injury doesn't cause autism. So this is not something that we did. His problems are unrelated to this. And this was a real dilemma for us. And until his mother got the diagnosis of C.V.I., we didn't have any explanation for this because, as it turns out, and this is the part that I thought was interesting, Ben, and I say Ben, Rahul, because Ben does a lot of med mal cases, is C.V.I. actually mimics autism. And it's something that anybody doing these cases, if they were like me and they didn't know that, if you have a kid who suffered a hypoxic ischemic injury, and now people are thinking there's something wrong with him and he has autistic-like behavior, they were ready to file what in Pennsylvania is a Fry motion, and they did file a Fry motion, whatever the people call a Daubert motion, because they're saying, well, HIE just doesn't cause autism. But it turns out that CVI is caused by HIE, and CVI mimics autism. And that was the watershed moment. That was the breakthrough moment. So we had to go back to our developmental pediatrician and get her to write a report that said, I was wrong. How about that? How about going to a renowned medical professional and saying, could you write a report saying I was wrong? And then you had to go to your neurologist and say, yeah, never mind. And then you had to go to, your vocational life care planner, economist, everything had to be changed. And this is all months before trial. And the defense, they thought that this was a completely fabricated thing that we had come up with. They thought that we were just making something up because the real case didn't turn out the way we thought it would. Actually, we were just sort of searching for the truth of this kid's life, this kid's diagnosis. And so when we ended up trying this case, we had to come in, and the first thing, Elizabeth did the opening in the case, and we had to say, hey, we're going to be honest with you here. For a long time, we had this wrong, and our experts had it wrong. We're just going to be honest with you. And we ended up trying this whole case basically with a theme of, we're going to be honest with you, and they're not, right from the beginning. Because that's all we could do. We had to come in and own it, that we had made a mistake. Our experts had made a mistake, that this was very complicated, but we now know what the truth is, and we're going to give you the truth, and they're not.
Did Hopkins or any of the other healthcare providers change their diagnosis with the child after learning about the CVI?
Interestingly enough, even though a lot of the medical records focused on symptoms and other issues that the child was having, once they had the CVI diagnosis formalized by his pediatric ophthalmologist, everyone else sort of said, "Oh yeah, this does make sense. These are the issues that we've been describing. This has sort of been on our radar from the start. It didn't make a difference therapeutically to the treatments the child was receiving. So even though it made all the difference in the world to the legal case and the malpractice trial that we were preparing for, it had kind of flown under the radar on the scope of the medical providers because it didn't change the treatments or the therapies or the recommendations for what he would be receiving."
Did the defense do any medical examinations after learning of your CVI? And then how did that all play out at trial? Did they stuck with their strategy of it's autism, and then they called all your experts advocates, or where did they go with it?
So the beauty of this, Rahul, was that if you're cynical, this case is your case. Because originally my concern was that this kid, we couldn't prove damages on this kid because he'd made such a great recovery. And so when we sent him to a developmental pediatrician, she said, no, there are really very serious things wrong with him, and it's consistent with autism. So they hired experts, and all of their experts, their goal was to say that there's really nothing wrong with him. So they all said that he doesn't have autism and that he's fine. And then when our expert said, "Oh, never mind, he doesn't have autism, he really has cortical visual impairment," then all of their experts changed their reports and said he really does have autism. And so we each went in and tried the opposite case. And honestly, it's maybe the most cynical defense that I have ever seen.
And in terms of the cortical visual impairment, and I've seen these cases where kind of by default someone is diagnosed with autism, but just it seems like just because in some cases people just don't know. What are the diagnostic criteria, and how does one test for that? Are there objective tests that can confirm or rule that out? The C.V.I. You're
Yeah, I mean, there are tests performed by an ophthalmologist, but also just tests sort of observing the child day to day. And that was one of the things we really needed to explain to the jury at the trial. How did these world-renowned doctors who evaluated this child arrive at a diagnosis of autistic-like symptoms and then a diagnosis of C.V.I.? So one of the things we did at trial is we actually got the sort of the ADOS, the autism diagnostic gold standard test materials, and we presented them in the courtroom. We had the developmental pediatrician sort of show the visual materials that the child would be asked about so that the jury could see how a child who had issues with cortical visual processing would answer the questions in the same way that would lead to sort of the yes boxes being ticked for autism diagnosis, but to understand that the reason the child was interpreting the visual materials in such a way was because of the visual processing, was because of the brain injury to that part of the visual processing center of the brain. I think that was a really helpful thing that we did at trial instead of just having the doctors describe the results of the tests that they had administered to actually demonstrate and perform. I mean, we brought in the actual picture books and sort of Where's Waldo type visual searches and all of the different testing materials so that the jury could really understand how the diagnosis of autistic like symptoms could result from a child with cortical visual processing problems.
Can you talk a little bit about your jury? How did you select your jury? What's the process there in York County, Pennsylvania, and who was on your jury?
Well, it's a lot better than Maine, Ben. We do actually get, voir dire, although I know that's changing a little bit now, partly thanks to you. But we do sort of a general voir dire, and then when people identify issues, then we're allowed to individually voir dire them. And so they come into a room in the back, and then each side asks them questions individually, one on one. And so it's a pretty robust process to get to the bottom of things. It's not like that crazy thing that I heard about in Connecticut recently in your show, where they do days of individual voir dire, and it's a constitutional right. The judges would lose their minds. But it's pretty much a full day process to pick a jury in Pennsylvania, in state court.
And who did you decide you wanted on that jury? It seems, I mean, just based on this description, you need somebody who has some healthy skepticism. Seems like you want people that are reasonably intelligent that aren't going to take everything on face value, but are going to delve into it. But sometimes those are also dangerous jurors to have in med mal cases. So where were you trying to strike the balance there?
Well, I can't speak for Elizabeth, but for me, I wanted to get the smartest jurors possible. I always try to do that. I mean, when I was a young lawyer and I did a med mal in central Pennsylvania, I struck everyone with medical or scientific training, and I ran out of strikes, and I had 3 people left. It was a hung jury. It's 9-3. We have 12 jurors in Pennsylvania. It was 9-3, and the only 3 people for me were the people I couldn't strike. And that was a really brutal lesson for me, that, maybe I was thinking about this differently than I should be. Because we try to put on intellectually honest cases. This is an example of it. We just came in and said, we've been trying to get to the truth for you, and here's the truth. Even though we were wrong in the beginning, we're going to admit that, And so in those kinds of cases, I think we want the smartest possible people that are, if you're putting on an intellectually honest case, I want smart people. So for me, I was looking for professionals. And I know we had, we even had an accountant on the jury, who, I don't know that he helped us at the end, but on the damages, but, we wanted the smart people on liability.
Yeah, with jury selection, it was really the classic situation that a lot of plaintiffs' lawyers face, where anyone who has a really emotional reaction to the brief summary of the case that they receive from the court self excludes. They say, I couldn't possibly be objective. My child was sick, or I had a family member who was affected by a medical error, and the court will excuse them for cause. Whereas everyone who has had a largely positive experience with the healthcare system will say, well, of course, Your Honor, I can still be impartial. I can put aside my own experiences. So you end up with a jury pool that is already skewed towards people whose own life experiences with healthcare systems and with treating providers have been largely positive. So, what we were trying to do in this case, since we can't help that, is we at least wanted to make sure that we got some parents on the jury. We knew that the defense would be combing through tens of thousands of pages of medical records to try and find any examples of this child sort of before the malpractice occurred to doing things that were developmentally behind peers. And we wanted to have parents on the jury to understand from their own family lives that just because your child is behind peers in one area or at one time or at one appointment doesn't mean that they are going to develop autistic like symptoms or be behind peers forever. And so, in the end, even though a lot of parents in the jury pool were excluded by virtue of saying, I couldn't possibly be objective here. We did end up with a lot of parents, especially a lot of fathers on the jury. And that ended up being something that we tried to cater the presentation of evidence towards, just establishing the normalcy and sort of the rhythm day to day of this child's life, of the family's life, in a way that would hearken to these jurors' individual life experiences with their own kids and their own families.
I was trying a case in Milwaukee once, and then we had a jury consultant, and her theory was that when you try cases with little kids, the juries all basically put the mother on trial. They're not going to they're not going to look at the kid, they're going to look at the mother. I don't know if that's true, but I think the defense thinks it's true because in our case, they did everything they could to strike the moms, the women, particularly women, but moms off of the jury. And we ended up with a largely male jury because they exercised all their strikes on women.
When you say put the mother on trial, I thought what you were getting at is that people would blame mom.
Yeah. Yeah. Well, if you have a case where the mom can be blamed, that is a factor. And in the case in Milwaukee I had, that was exactly the defense. This case was a little more difficult. These parents were so good. They were so exemplary that they had to take a different tack. They couldn't blame them at all. They had to say things like, "This kid's going to have great opportunities because of the wonderful job that the parents done." They just couldn't attack these parents.
Can you talk a little bit about your approach to the damages side of the case?
Chuck is laughing. So whenever we work together, Chuck is just an absolute force of nature with the experts and the doctors and the defendants. He often says, "Well, Elizabeth, we do need to put on a damages case as well." So, damages are something I think of from the start of the case. How are we going to frame what happened here to the jury? What are the visuals? What are the moments that we can present to the jury as examples of the sort of diagnoses, of the effects on daily life? Because unless we bring this to life in a really emotional way for the jury, then they're not going to really translate liability to dollars and cents on the verdict slip. So, one of the things we did here for the damages case was we combed through these parents' phones for all of the videos of their child, going back to, when he was extremely little up until I think with the most recent video, we had one from 3 weeks before we presented it in evidence. And we culled through those to really find ones that exemplified moments where you can see this little kid affected by his injuries. You can see him alongside his peers, alongside his sibling. They're doing things that we knew the parents on the jury would recognize as being not typical for a child that age, not developing according to sort of the normal social and emotional timeline. Those visuals, we knew we were on to something when the defense would just argue. It was all out war to get those things to be used at trial. And so we knew how big a threat the defense clearly thought that those videos were, that those photos were, because just playing a 10-second clip for the jury could convey something better than 10 minutes of cross-examination could. So those became very powerful evidence for us.
I always get surprised in every case by there's something that I don't expect. And in this case, I was doing an exam, and this is one of the benefits of having two people at trial. And Rahul, I don't know how you guys do it, but I can't imagine trying a 3-week trial without another attorney. I can't. I'm not smart enough. I can't possibly do it myself, and I don't know if other people do, but I was doing an exam on a witness, and Elizabeth kept handing me something, and I kept ignoring her, and she kept handing it to me, and I looked at it, and I was like, "Yeah, okay." And finally, like the third time, she just pushed it into my face and said, "You need to use this." And I got up, and it was the summary of the adoption. This child was adopted from China, and it was a summary of the adoption, and it was a description of this kid written in sort of broken English by somebody who was translating it from Chinese. And it became like the most powerful moment in the trial, and I would never have had it, I would never have seen it, she saw it, and I started reading it, and I still get choked up about it. The first line was, "He's a good boy." And I read that, and I almost started to cry. And the mom, she started to cry, and some of the jurors started to cry, and it was just like the most powerful moment. And I never could have predicted that. I could barely get through the description that started, "He's a good boy." Anyway, that was something that reminded me I'm never trying a case alone again, because it never would have happened if she weren't there showing me something that was so obvious to her that I had missed, that became maybe the most powerful moment in the trial.
Amazing.
It was a real showstopper moment, and it's something that's only possible when you are immersed not only in the evidence you're planning to put on, but also in the evidence that the defense is going to be using. This was not a record that had been on our exhibit list. This is from a record set that the defense had wanted to put in,
Oh,
because in the
wow.
other pages of the record, there's all sorts of little, check boxes and things about developmental delays and other concerns at the orphanage where this child had been at pre-adoption. But, in the course of reviewing that to pull out the sort of opposition research so we could be prepared for what was coming, we had seen that there was this page. There was, when presented in a heartfelt, emotional way, what we had brought up just to sort of show, to refute one of the experts, became one of the biggest heartfelt moments of emotion in the courtroom.
Amazing. Prior to that moment, was this jury kind of a poker face, stone faced jury until that moment, or could you feel that they were seeing the evidence unfold the way that you two were seeing it unfold?
I feel like the juries are always poker faced. I don't know. Maybe Rahul, they probably love you. Ben, they love you. I don't know. But the one thing that I will say is that I felt good about was that this jury for 3 weeks, we excused a juror who was falling asleep. The juror just got kicked off the panel. But other than that, these jurors were as attentive as I've ever seen any jury be. And so I felt good because they were paying attention, but until that moment, I didn't know that they were on our side.
That was a real tonal shift during the trial from we'd been trying to channel a sense of outrage over what the defendant doctor had done and how egregious an error that was. And then to shift to the effects of that error, to the life that this child would have had, but for the doctor's just terrible mistake, preventable error.
I don't know if you've ever had this issue, but our mom was a fantastic mother, but it was hard for her to be a witness. She didn't want to let her guard down. She didn't want to let anyone see how much this had hurt her. And we were lucky because her testimony was split overnight. She started late in the afternoon, and we really had to talk to her about letting go. And then the next day, she just all of a sudden became herself, and it was night and day. And I don't know if you guys have any techniques for that you want to share, but one of the hardest things I think is for some clients just have a hard time being vulnerable and letting their guard down in a trial.
I think oftentimes there's a version of survivor's guilt that happens too, especially with parents. They knee-jerk reaction is to take personal responsibility and say, whatever happened, it's my fault. And they won't articulate it that way, but that usually puts up a huge guard. And then starting to appreciate that it's not their fault, then starts to open up the floodgates of how they're really feeling. But it's hard to navigate those issues. But you two clearly did a good job of connecting with her and building that trust, which is, I think, the start of getting to the point where she testifies like, you know, authentically.
It's just hard because this client has suffered so much, and you're sitting there like a director going, "Yes, but this time with more feeling." Like it just how
Yeah.
do you how do you have that
Yeah.
conversation?
Yeah, it's always a good reminder that so many clients just need to hear from you that the strongest thing you can do right now, the best way you can fight for your child or your loved one is to let your guard down, is to talk very openly and candidly from the heart about the obstacles that your child now faces because of his injuries.
So one of the most fun parts of every trial are the unforced errors or the overreaching or the boneheaded comments you get from overly aggressive defense lawyers. Did you have moments like that here where you felt they overplayed their hand or did something that was a gift for you? And in what context, if it did happen, in what context did it happen? Or I guess I would extend that to maybe their experts on cross or anything else. Elizabeth's smiling, so I know there's something here.
Yeah, there were a few. One of the blessings of this case was that there were two defense teams of attorneys, one representing the hospital, one representing sort of the individual practitioners. And during the course of the trial, there would sometimes be objections or even just sort of speaking questions raised by one team or the other that would help advance the point that we were trying to make. I remember one where we were trying to demonstrate that the findings of the treating provider's evaluation were nearly identical with the findings of the retained expert that we had had examine the child to do her evaluation. And so I had made a graphic that put up on screen quotes from the report of the treating provider in one column, quotes from the report of the retained trial expert in the other column. And I hadn't labeled them. I just put them up on screen for the jury to look. And the hospital's attorney stood up and said, "Objection, Your Honor. She hasn't said which column is from which report." It gave me an opportunity to just say, "Well, yes, thank you. That's exactly my point." To ask the witness, "Are you even able to tell which of these comes from which report, the treating provider or the expert that we retained?" Um, so it's always fun when there's a moment where opposing counsel sort of helps you make your point, helps you make your case, and I know that that was one that Chuck and I took some enjoyment of.
So you guys managed to have some fun when you're traveling in Pennsylvania for 3 weeks. Is there what's the out of court protocol, the morning routine, the evening routine? Is this a Cullen and Cullen situation where you're draining the bar dry of the whiskey and wine, or are you guys behaving yourselves and getting a good night's sleep? What are you doing?
Well, nobody got a good night's sleep. It's a small town, and so we're staying at the same hotel as the defense lawyers, and so we're going down at 2 a.m. to get something from the front desk, and they're there too. It was really that kind of scene. There was, I'm sorry to report, it's not like it's it was all work and no play.
Can you share with the listeners what's the verdict?
Well, we just got our judgment from the judge. They filed post-trial motions, which were denied in a rather emphatic way by the trial judge. And so it was about $10.5 million.
Okay,
Which,
so
Rahul, listen, it's a little embarrassing to come on here with you because that's like the interest on your verdicts.
Stop it.
But I
Stop.
mean, in small town Pennsylvania, it's a pretty good verdict.
That's amazing. And then what's the status now? Post-trial motions are done. Are they angling to appeal, or are they going to finally do the right thing and make sure this kid is taken care of?
Well, I got a call from the appellate lawyer on Monday who wanted me to make a demand. And it was an interesting conversation because I was like, "What do you mean make a demand?" The judge just entered an order. That's my demand. Like if you want to make an offer, make an offer. But
Yeah.
there's the demand. So they're going to appeal it, and you get 6% in Pennsylvania post verdict. So I mean, it's $650,000, a year. So I mean, they're inevitably going to appeal it. So, but they it made me think of you, Rahul, because they had to post a bond.
Oh, great.
And I remember it was a big moment for you in the jujitsu case, right? When they posted the bond.
Yes. Oh, that made my day. Oh, that's fantastic. Your client's going to get justice soon, hopefully. How long does the appellate process work in Pennsylvania? Year, two?
Yeah, I would think 10 to 12 months. It depends on how
That's
many,
great.
motions for reconsiderations and motions for rehearing on bonk and all that kind of stuff that, that they end up doing, but something.
Do you have a preference motion standard in Pennsylvania? In California, if there's a child under 14 years of age under CCP 36, we can get a trial in 120 days, and then that same standard applies through the appellate process. I don't know if they have something similar in Pennsylvania.
Well, if they do, then I committed malpractice because I didn't,
Mm.
I didn't, I don't
No,
know
no, no,
about,
no.
I don't know about it. And I can tell you that we got our trial in about 4.5 years. So
Yeah.
well, guys, that's really a fantastic result, and well, I mean, your client is so fortunate to have you because I can't imagine there are many lawyers in America who could pull off what you did and change the course of your thinking about the case and put that together the way you did at the last minute to get that result.
It's
So,
amazing.
yeah. And
And
thanks for coming on
congratulations.
and sharing it with us. It's been too long since we've had you guys on or have Vernon and Simmons folks. So
well,
thanks for doing it.
thank you so much for having us. And we really enjoy your podcast. Thanks for doing it.
Yeah, thanks for having us here.